Thank you. Really appreciated the morning, and thank you, Mr. Hensley, for a wonderful talk. And one of the first books I read on Alaska, pretty soon after the book came out, was his book, and I still recommend it to sort of all my students. It's a terrific insight into the cultural and political legal history. If you're not a lawyer, you're a pretty good one. So our next panel, if you kind of think about the organization of our panels, it was something we talked a lot about. It's hard to know exactly how to divide speakers up. These things cross ideas and concepts. But this second panel is called Alaska's Role in Managing the Development of the Arctic North. Our two speakers are Barry Zellen, who is with us telephonically. He's a noted author. A range of sort of areas, war and strategy, Arctic geopolitics and indigenous cultures, a very wide-ranging thinker about the problems of the Arctic. We also have Professor Betsy Baker, who has taught at a number of institutions, including the University of Vermont, is now in Alaska this semester working with the University of Washington, and is I think going to be a very interesting speaker. She's her description is quite impressive, I think, in terms of the and really quite happy that she's here. I heard her speak at a conference at Duke and was tremendously impressed by her sort of range of knowledge and issues about some of the topics that we think are central to our program today. We have two commentators as well. Bruce Anders from the Cook Inlet region. I notice he is a Duke grad from 1989. I have to think back to what basketball players are in that era. That's how we date everything at Duke.
Danny Ferry and Quinn Snyder.
So he's the Danny Ferry and Quinn Snyder. Quinn Snyder was one of my favorite students. He went to Duke Law School and then is now coaching, which is probably something all of us would like to do. But then went to the University of Oregon for School of Law, and his perspectives from being with CIRI will be terrifically helpful for us. We also have Mike LeVine, is not listed as a commentator, but he is here. He's with Oceana as senior counsel, also a Duke Law grad. This was not totally intentional to have quite the Blue Devil, but since Mr. Hensley called out Richard Nixon, and in a favorable way, that doesn't always happen. In case you did not know that, Richard Nixon is our most illustrious alumni of the Duke Law School.
Thus far.
Thus far. Yes, the rest. Who's next? So he is a class of 1937. So we are a little bit behind. So Barry, we'd like to ask you to go first and maybe spend about 15 minutes sharing your paper, and then we'll have Betsy present. We are going to kind of keep the clock on it, even though I can't see it, but somebody else will help. I'll get my phone in a minute. So Barry, please go ahead.
That sounds great. And if I start to run over, just let me know once or twice, and that should help to get the brakes on me if I start babbling.
Okay, thank you.
I want to start by thanking Professor Portson at UAA and also Philip Tarpley at the Alaska Law Review and all their colleagues for the kindness of inviting me to participate today in spite of my geographical uncertainty and my inability to attend in person. I also want to thank everybody on the panel, Professor Baker, Moderator, Professor Metzloff, and the commentators, Bruce Anders and Mike LeVine. And my thanks to all the attendees as well for your patience with my remote presentation by phone. My fingers are crossed that I come out clearer by phone than I do in person. And if the case is not true, I do have copies of the paper available for afterwards that might help to offset that. Our topic is Alaska's role in managing the development of the Arctic North. My perspective on this has been shaped by about a decade or so spent in the Yukon and the Northwest Territories across the border, during which I had the great privilege of working for a number of Aboriginal media organizations, and at the same time pursuing research in the 1990s and into the 2000s on how land claims has transformed the political economy of Arctic North America. In a nutshell, Alaska's role in this grand sweep of political, economic, and constitutional development was to introduce a new paradigm with ANCSA, the Alaska Native Claims Settlement Act, over 40 years ago, and serving as a catalyst to what we can think of as a land claims revolution that would sweep across the entire North American Arctic between 1971 and 2005. The Alaskan experience was the spark that ignited this revolution, providing inspiration for a new way of reconciling state and tribal interests in the North. The process was far from smooth. It consumed several generations as the land claim models itself began to evolve and respond to developments in native rights law. It was far from perfect as a process, but it was always moving forward. My following remarks, derived from a longer draft paper, capture at a high level the contours of this forward movement, as well as some of my current thoughts on implications for today's world. With much of the paper looking at the Inuit experience, and to a lesser degree, the Athabascan experience on overlapping lands. Since the modern state first encroached upon the pristine and sparsely inhabited homeland 400 years ago, the Inuit of the Arctic have aspired to restore their Aboriginal rights and traditions, and to reclaim and extend sovereignty as much as possible. As the Inuit learned more about the systems and structures of governance that were exported from Europe, and later the newly independent states of North America, they found ways to restore many lost powers of self-governance through innovative diplomacy, negotiation, and various forms of political protest, and a very adept use of soft power. This greatly contrasted with elsewhere in the Americas, where the modern state collided much more forcefully with the interests and sovereign aspirations of tribes from the late 15th century onward. By the time the presence of a rapidly modernizing state began to be felt up in the north, methods for asserting sovereign control began to mellow. The days of imperial conquest, with hard power shifting to soft power, and treaty negotiation replacing conquest, for the final integration of these last virgin territories into the American and Canadian polities. America purchased Alaska from Russia in 1867, and with it, Russia's assertion of sovereignty over Alaska's interior tribes. In Great Britain, and later the Federal Dominion of Canada, after its formation also in 1867, negotiated a series of numbered treaties, nation to nation, that brought Western tribes into its expanding confederation. Thus, largely through negotiation between two unequal tribes, the new territories of the far north entered into southern control without, by and large, recourse to war, with few exceptions, such as the Métis Rebellion from 1871 through 1885, and a series of skirmishes and punitive strikes between the 1865 Battle of Wrangell and the 1882 bombardment of Yangon. Because the political integration of the far north was achieved largely without war, the preferred tools for reconciling interests of tribe and state would remain predominantly nonviolent, modeled on the treaty process, with negotiation helping to bring some balance to the many other asymmetries, such as economic and military power, that separated the indigenous tribes from the modern states laying sovereign claim to the north. By the time of the civil rights movement in the lower 48, the seeds for a more formal reconciliation of state and tribe had been planted, giving birth to the land claims movement that has, over the last half-century, transformed the political economy of Alaska and also Canada's territories. This half-century wave of structural innovation has transformed the political economy of Arctic North America, stretching all the way from the Bering Sea to Baffin Bay, with the completion of a multi-generational process of negotiating comprehensive Aboriginal land claim treaties to settle issues of land ownership and to foster a more enduring partnership between the indigenous peoples and the modern state through a slew of new institutions, including Aboriginal, regional, and community corps, investment corporations, land administration agencies, a variety of tribe-state co-management boards, plus a complex patchwork of local, regional, and territorial governments created to give a voice to the native interest. The historical process, seen from Alaska in the west to Labrador in the east, has been largely a two-step process. The first step was to address the land question and to negotiate, and in most cases implement, land claims accords to bring clarity of title, helping to identify who owns which lands, and to reconcile the competing interests of tribe and state, and thereby open up, or for sensitive ecosystems and traditional hunting lands, to close off the region to economic development with various mechanisms of co-management, helping to keep native and state interests in balance. Once land claims were settled, the next step in the process of northern development has been the pursuit of new systems of Aboriginal self-governance, taking various forms and employing various structures over time, from the establishment of municipal or bureau governments under existing constitutional law, as we saw in Alaska in the 1970s, to the creation of newly empowered tribal councils governed by federal Indian law in Alaska in the Northwest Territories in the 1980s and the 1990s, or the negotiation of entirely new systems of governance, with the most ambitious being Nunavut, with its comprehensive land claim settlement in 1993, linked to the subsequent formation of a new territorial government in 1999, creating a complex and potentially powerful system of self-government, applying a public model to a predominantly indigenous region for de facto indigenous self-government. after Nunavut, the evolution toward more distinctly indigenous self-governing structures has continued, as reflected in the Labrador Inuit land claim of 2005, with the very first truly Inuit self-governing structure whose governing principles are articulated in a detailed 2002 Labrador Inuit Constitution. More recently, in 2008, Greenland held a referendum on evolving toward sort of beyond their home rule system of autonomy toward a more formal state sovereignty and independence. And while non-binding, it passed decisively, paving the way forward for an eventual emergence of what might be a formally sovereign Arctic state with a majority Inuit population, with literally revolutionary, if not just evolutionary implications for the rest of the Arctic region. Regardless of jurisdiction, whether in Alaska or Arctic Canada, or even beyond the shores of North America, the Inuit have shown tremendous ingenuity in their efforts to build new systems for self-government since the land claim movement took root back in the 1960s, creatively adapting existing institutions or creating new ones whenever possible, lobbying for or negotiating to further advance their powers and wealth. With the land claims model evolving along the west to east arc, all across the north, becoming stronger with each new iteration, and transforming the domestic balance of power to increasingly favor the very tribal interests that had earlier in history been marginalized from power. With regard to the institutional empowerment of the Inuit and other indigenous peoples in the north, Alaska's role has been foundational and inspirational, transforming the very paradigm of northern development on many levels. When ANCSA was enacted, it aimed to quickly bring Alaska natives into the modern economy, and at the same time to clarify the limits of Aboriginal title, making it possible to fully develop the state's natural resources, and in particular to build the Trans-Alaska Pipeline. Because its objectives were largely economic, its corporate model became its defining and most transformative characteristic, and not without controversy, since the corporate model was viewed with some skepticism by indigenous leaders and advocates of native rights as a tool of assimilation. And there remains a continuing debate over the appropriateness of the corporate model to the indigenous north, as well as continuing growing pains with regard to the alignment of corporate culture with native culture and corporate values with traditional values. In addition to the corporatization of Village Alaska, ANCSA's original design also had some structural flaws that nearly proved fatal to the land claims experience, including the 20-year moratorium on transferring shares in native corporations to non-natives, which many feared could inevitably result in dilution of native ownership. And this is called the 1991 time bomb, which has been more or less addressed, not perfectly, but practically, as well as exclusion of new natives born after the claim from automatic share ownership. While critics of the land claims process are correct to point out these original structural flaws and the assimilating pressures introduced by new corporate structures, the land claims model itself has nonetheless proved resilient and adaptive as new native corporations matured and their boards, managers, and shareholders found new ways to better balance traditional and modern values, learning from what was really a crash course in capitalism as they went. So today, the native corporations represent a significant economic force in the state of Alaska. Just across the border, the Inuvialuit of the Western Canadian Arctic had a front row seat to ANCSA, and they were really impressed by all the money that was flowing north into Alaska villages, as well as the new corporate structures that were created, as well as the sizable land quantum formerly transferring title to Alaska natives. But they also saw a continued threat to native culture from the very pressures of modernization and a lack of adequate protections on subsistence, as well as environmental protection. So they were determined to try to do better. When the Inuvialuit negotiated what became the 1984 Inuvialuit Final Agreement in the late 1970s, the land claims model became significantly enhanced. In addition to creating new native corporations, the IFA also made an equal institutional commitment to the preservation of native culture and traditions, and to preserve the land and wildlife and empower not just new corporate interests, but also traditional cultural interests as well, by creating new institutions of co-management and more powerful hunters and trappers committees. They also made sure that all Inuvialuit became shareholders and that no non-Inuvialuit could ever, learning from the Alaska experience in the 1991 time bomb. The Inuvialuit successfully modified the model so that the structure of their claim included a natural institutional balancing, not really at all unlike our own balance of power system. And this has enabled a greater commitment to cultural and environmental protections along with economic development. But there was one issue that wasn't yet on the table in the 70s and the 80s when the Inuvialuit chose to pursue their claims and thereby gain some control over the intense oil boom taking place in the Western Arctic. and that was the establishment of new institutions for Aboriginal self-government, something the Inuit of the central and the eastern Arctic, the future Nunavut territory, decided to wait for. The Inuit felt they did not have the luxury of given the frenetic pace of gas and oil exploration on their lands. But Nunavut had remained more isolated during that period, so it provided more time to rethink the model and renegotiate the land claim structure. In the years separating the signing of the IFA in 1984 and the signing of the Nunavut land claim in 1993, a lot of progress got made on the political question, and an increasing respect for Aboriginal rights in Ottawa enabled the establishment of a new concept, the reshaping of political boundaries to correspond to land claim settlement areas, and establishing a new government to administer the region, augmenting the land claims with real political power. The most striking innovation of Nunavut was the way that it formally linked the division of the Northwest Territories with the formation of a new territory that resulted in 1999 with the birth of the Nunavut Territory. Nunavut's now been up and running for a decade or so, gaining valuable experience, but often painful experiences as well in self-governance. Showing the many strains that as it struggles to confront some very daunting social and economic challenges in what's one of the most challenging geophysical environments that one can imagine. Half a decade after Nunavut, the final Inuit land claim along the North American Arctic coast, the Labrador Inuit claim, was settled. It was ratified in December of 2004 and came into effect about a year later, presenting a new stage in the evolution of Inuit governance, making what was a two-step process now a one-step process, and further redefining the limits of self-government within a land settlement area, transcending the public model that the Inuit of Nunavut had applied, and that the Inupiat on the North Slope had applied as well. Just as the formation of the Nunavut Territory was the salient innovation of the Nunavut land claim, the emergence of a truly Inuit style of self-government became the hallmark of the Labrador claim. As described in Section 17.2 of the claim, it exhaustively set out the lawmaking authorities of self-government rights of Inuit, with the newly created Nunatsiavut government to be a fundamental law of Inuit, as enunciated in the 159-page Constitution, which included an Inuit Charter of Human Rights, recognized Inuit customary law, and its application to any matter within the jurisdiction and authority of the Nunatsiavut government. It also embraced laws to protect Inuit culture, language, and traditional knowledge in a region that was adjacent to coastal waters of emerging strategic significance with active commercial and subsistence fisheries, major strategic mineral deposits, and the prospect of much future economic potential. It also showed a new path toward Aboriginal self-government, one that did not require a formal secession of Inuit communities from another region like we saw in Nunavut, but instead forged a regional sub-government within an existing province with distinct needs for Labrador's 5 Inuit villages, but one that had unique governing principles for those villages. The Arctic land claims model.
So Barry, we're
any
at
subsequent modifications.
Barry.
Yes?
Yeah, we're at 15 minutes now. So if you, I can hope that maybe we can finish up in a minute or two because our schedule is a little tight today.
All right, let me quickly zoom to the conclusion.
Okay, thank you. Anyway, we'll have
The
time for
Arctic land
comments.
claims model, with many modifications, has become an inspiration to many. Proof positive of what can be gained through a determined forward-looking effort to rebalance and modernize the relationship between Indigenous people in the North and the modern state. And Alaska's role was really in getting the ball started, and one that has had a lasting multi-generational effect on the entire North across several generations. And the model for land claims was envisioned, and I think part of the breadth of its success and its ambition was partly the isolation of the region. And while there were development efforts in natural resources, it was moderated greatly by a permanence of Arctic climatic conditions. And now, with climate change and uncertainty to the geophysical landscape, it raises many questions about whether these structures, as they were imagined, might need to again adapt and evolve to a new dynamic sort of change within the environment. And I think just a closing note, one of those sort of issues and vectors to think about is the sort of international environment. And I was thinking a lot about what happened in Crimea and some of the new international unrest with a resurgent Russia. And Russia is a major Arctic power. And one question to close is, as sort of the environment of the Arctic might shift toward greater conflict potentially, how might these structures come into play, and how might foreign powers respond to the claims process and its history? So I tried to grapple with some of that in the second half of my paper, but for reasons of time, I think it's best to maybe wrap right about here.
Yeah, that's great, and we'll have time for some comments and questions during a little bit of Q&A at the end. So thank you very much.
Oh, my pleasure, and thank you for
And everyone here has a copy of the draft of your paper, so they will be able to read that and get in some more of the details. So thank you. Thank you. And so next up, Professor Betsy Baker from the University of Washington School of Law.
Thank you, Tom, and thanks to Duke and UAA for hosting this event, and to all of the editors of the Law Review who will be working on our papers. And Barry, thanks to you. Yours was one of the first books I read when I started looking at why it is that on the Canadian side of that maritime boundary there seemed to be much more involvement of the Inuvialuit in marine mammal management than on the U.S. side. So I'm really sorry you're not here. It'd be fun to meet you. Okay. Yeah, thanks so much. And thanks also to Willie Hensley for his wonderful talk. As someone trained in history, I very much value that perspective, and Barry's also, to get us to think about what models we have that might be adapted to problems that we are facing today. And I owe special thanks and apologies to my commentators for not giving you much to react to before the fact. So I'll state the question up front. What I'm really interested in, especially from the many practitioners in the room as well who know a lot about coastal management, in the absence of coastal zone management now in Alaska, what are other models you know where the federal government and the state government actually work happily together? So that's, I'm seeing smiles around the room, but I should step back, I guess, and for everyone else in the audience, start with the problem statement for my talk. And some say that the problem is that Alaska no longer participates in statewide or federal coastal management. I think a more precise problem statement is that very few people are studying whether that lack of participation is in fact a problem, although the consensus here seems to be it is, and whether there's a need for some sort of substitute for what was known as the Alaska Coastal Management Program, or ACMP. So in 2011, when Alaska stopped participating in the National Coastal Zone Management Program, it became the only coastal state in the country not to take advantage of consistency determinations and funding opportunities under the Federal Coastal Zone Management Act. It had participated voluntarily for 34 years until the state legislature declined to reauthorize the program in 2011. Under that program, state authorities reviewed proposed resource development activities for consistency and compliance with the state's coastal management program, which included state laws, state standards, and district enforceable policies. This meant that federal activities that would affect state or private coastal lands had to comply with state law, which in turn took into account the coastal plans of local communities. Today, there appears to be no mechanism to ensure that such federal activities have to comply with state law. In a state that often decries federal overreach, this is an odd situation. And it's a situation that affects the entire coastal zone of Alaska, but seems especially important for Arctic and subarctic Alaska. So I just touch anywhere? Good. Okay. So those of you who've seen me talk before, so does she always start with this slide? And the answer is yes, I do. Because it's just a wonderful reorientation of your perspective, especially if you're not used to looking at the world from the north. And so this is also a favorite because it shows what collaborative science can do. Marine geophysicists from around the pole and around the world put this together with their various sets of data for a pretty picture of what the Arctic Ocean seafloor might look like. So just take a look at that and study it for a bit. As a law of the sea scholar, most of my career has focused primarily on international law, most recently in the Arctic, but if you care about wise use of either international or federal waters, you eventually have to look at where those waters meet the national coastlines of the 5 littoral states that ring the Arctic Ocean. Conversely, if you have a stake in how the state of Alaska's water and coastline develop, you need to pay attention to what will be arriving from waters farther afield. For example, we've heard about increasing activity along Alaska's Arctic and subarctic coasts. Practically, that means that vessels passing through the Bering Strait from 2008 to 2012, 118% increase in that vessel traffic, from 220 in 08 to 408 in 2012, and climbing. What about the need for a new Arctic, or for an Arctic or a new subarctic deepwater port? We've heard studies from the federal government on the point clearance area as a possibility. Even these 2 examples indicate some ways in which the state of Alaska and the federal government need each other in the Arctic. And I'm switching now to my new favorite picture. It's not a map, it's a real photo. So this is a satellite image taken in, the date is important, June 17th, 2013, of Alaska from space. And I should say some of Alaska because the Aleutians don't show up there. So without Alaska, the U.S. is not an Arctic nation and would lose more coastline than all of the other 49 states combined. Without the U.S. government, Alaska would have no Coast Guard, no adjacent outer continental shelf, no federal funding for the science, emergency response, and infrastructure projects such as deepwater ports that will be essential to safe, economically, and environmentally sound development in Alaska's north. We know that we've heard a bit from Fran about the Alaska Arctic Policy Commission. I'm delighted that Nils is here as one of the members of that commission. In 2013, the state established that commission with the task to articulate Alaska's state policy in the Arctic. On the federal side of things, I also refer to Fran's reference to the multiple strategy policy statements since 2009. I've tallied it at 16 now from various federal agencies talking about what we should be doing in the Arctic. Both levels of government, state and federal, are trying to give shape to this notion of integrated Arctic management, a concept that's central to many of the federal policies but still poorly understood. So a lot of policies but no real good concrete examples of forward-looking plans for balancing development and conservation in the North. Proponents of the now defunct Alaska Coastal Management Program saw it as a useful tool for balancing those interests and for local communities to have a say in coastal development. Opponents say it was added bureaucracy. So this presentation does focus on the Arctic, but I think realistically any replacement for the ACMP would need to be statewide. At the same time, I want to highlight both a workshop that took place in Anchorage in 2010. Both the Alaska and Fairbanks campuses collaborated on how do we think about improving coastal management. And one of the outcomes of that was we really do need to consider there are subregions, that Alaska's coast is very different. And if you look in June, all of the North Slope was still in ice. And if you look down toward Kotzebue and Nome, you begin to see some of that ice diminishing. You can sort of take a walk around the coastline yourself. But at 6,600 miles, Alaska's coastline is longer than all other states combined. 206 coastal villages are spread across this vast coast, which encompasses, under state law, 4 distinct regions: northwest, southwest, south central, and southeast. And in southeast, you have fjords, and in the north, you have vast, flat coastal plains. So it's quite varied. So this map helps us to visualize how broad a coastal zone can be under the federal Coastal Zone Management Act. The coastal zone includes not just coastal waters, but adjacent shorelands, islands, transitional and intertidal areas, which means for the coastal plain up north, it can be as broad as 25 miles inland, right? So we're not just talking about where water meets land. But no matter where a village is located along the coastline, chances are coastal flooding and erosion poses a threat to it. And as you can see from this map, it's not just on the coast, but it's also inland along the rivers that those are problems. In 2003, a General Accounting Office study commissioned by Senator Stevens found that coastal flooding and erosion affects 86% of Alaska Native villages. 10 years later, in 2013, it had been shown that little progress was made and 31 villages were imminently threatened. Would the return of coastal management program matter to those villages on the coast? Bruce Patello, the former mayor of Juneau, writing in 2012 in support of a ballot measure to create a new coastal management program, had this to say, and is sort of an indirect answer to my question. The ability to affect federal actions such as offshore oil and gas leasing and activities on federal land was a major reason Alaska established a coastal program over 30 years ago. Today, and here I want you to remember Mara's map, that vast swath of 63% ownership of federal lands. Today, the federal government retains ownership of about 60% of Alaska lands, much of it along the coast. Considerable offshore activity permitted by federal agencies occurs beyond the state's 3-mile limit. The state coastal program needs to be revived because it provides the means for the state and local coastal communities to substantively influence federal actions that are otherwise out of state and local government jurisdiction. And here I recall what Willie Hensley said, that if you are not at the table, or if you're not behind those doors, then your concerns are not heard, no matter the setting. I do want to highlight that the ACMP was not on its own anti-development. Proponents, Beth Curtail among them, say it in fact streamlined the permitting processes for development. Major developments as far south as Juneau and the Kensington Gold Mine and as far north as Prudhoe were all accomplished with that act in place. So everyone seems to agree that it played the role of a one-stop shop for project developers seeking permits. But is that one-stop shop necessary, is a question I will ask very neutrally and probably naively. So I referred to that workshop here back in 2010. Shanda Meek is a colleague at Fairbanks, and with colleagues there, she put together this really helpful map. I'm sorry, it's probably a little too small to read, but if you look at the very center, you can see the Alaska Coastal Management Program as the node. And it's a node if you're starting at 1 o'clock for federal agency effects to have to pass through, or it was a node, I should say. If you look then at about 4 o'clock, all of the federal permits, and those various dots around the 4 o'clock are the different agencies that have some role in permitting most major development projects. If you move up to the left at about 9 o'clock, state resource agencies also had to put their information through the Coastal Management Program. And then up at about 10 o'clock is coastal districts, and the figure is different now. There were 28 at that point, and I think 35 at the peak before revisions. So what's happened, in effect, is that node, if you look at the red X in the middle, is no longer there. Right? So whereas before you had to pass your plans for development through the Coastal Management Program, that doesn't happen. And all of this permitting activity continues, but there isn't sort of a centralized mechanism, especially to bring in the voices from about 10 o'clock, the coastal districts, with either the borough or district plans to be considered. I realize I still haven't given you a real clear picture of exactly what the ACMP did, but so here, just looking at some of their early materials, having a federally approved coastal management program allowed the state to balance economic investment and development, act as the state's liaison to federal agencies, apply state ACMP enforceable policies to federal agency activities, and especially to provide those project applicants with a single point of contact for state review of resource development permit applications. Again, for consistency with state rules and state standards and local and district coastal plans. Program worked quite well. Initially, the agencies responsible within the state learned how to streamline their own internal permitting processes. Then things started to change a bit. In 2003 and 2004, there were fairly major both legislative and regulatory revisions that indeed caused the federal agency, NOAA, that had to approve these plans to express some concern about how it was working. I won't go into detail for a matter of time, but eventually the program became weaker. The biggest change was that the Coastal Policy Council that had facilitated all of the public input was basically removed, and that the program became the sole responsibility of the Alaska Department of Natural Resources. Even before those changes, though, funding differences between wealthy and less wealthy boroughs meant that richer communities had more developed plans, and that often the poorer communities had plans that amounted to little more than a redundant compilation of what was already in the statute. One manager has commented, if it's already in the statute, why repeat it in the plan? It just, at that level, seemed like a lot of extra work. Anyway, this weakened structure became less and less effective. The legislature failed to reauthorize in 2011, and despite a compromise bill that some had hoped would restore some of the strengths and give the state an even greater say over federal activities affecting state waters, it expired at sunset in 2011. So we have the scenario now before us. Briefly to ballot initiative that took place the year after in 2012, and I put this figure up just to, it's a snapshot, it's not a complete picture. The ballot initiative to put in a coastal zone management program failed 62% against, 38 in favor. But as I've read the coverage around it, and this is where I'd appreciate feedback from others in the room, it was in part because as drafted, it was too complex, maybe, and I know Lisa has probably a lot to say on this, and that it also, as presented to the public, there were just a lot of issues as to how it was presented, and that the actual impulse for coastal zone management is still there in many fronts. But I also think the financing behind the ballot initiative, or the ballot measure, is interesting to see. That $63,000 of those supporting it, the North Slope Borough, Bristol Bay Native Corp., and others, as opposed to almost $768,000 to defeat it, right, from a range of interests, Alaska Miners Association being at the top. And I'm also not sure that financial breakout is actually representative of the actual discussion of those who are quite interested in the topic today. So I just put that up there for reference. Now this slide, you may wonder why I have the Alaska Department of Natural Resources land plans up here, but it's to show that Alaska does know how to plan. It's not as though there's an opposition to planning per se. That these plans for land use, obviously in the coastal areas, will need to take account of development along the coast as well. Before I move on with that slide, let me just mention a few other practical effects of there not being the Alaska Coastal Management Program. And Chris can maybe correct me on some of this, but taking the Northwest Arctic Borough as an example. So the coastal management plan there, as I understand it, was never approved. And again, my facts may be wrong here, but that there are still, however, ordinances on the books that refer to the existence of that state plan, right? And it's not just that borough, it's a lot of boroughs. If you have to redraft all your ordinances to take out references to laws that no longer exist, what burden is that? The Planning Commission there and in other boroughs has, by ordinance, the responsibility to review and recommend amendments to the district coastal management program, right? So what's going to replace that at the very operational level? So looking at this map a little more closely, the state has 20 area plans. And in part to my commentators, I ask whether is there anything in the operation of this type of planning that could play a role in somehow replacing the Alaska Coastal Management Program. I think, how am I doing on time? Okay, then I will skip over this section. But what I've done And this is, I'm really just at the start of this section of the research. Obviously, I'm teaching myself some of the background, but now I get to the question, okay, if you don't have the ACMP anymore, what's out there that might work? Whether it's a state planning function, whether it's a federal policy that talks about integrated Arctic management, whether it's a model we can take from one of the land claims agreements on how in Canada, right, as to how they do coastal management. And can we begin to find principles that are common to each of these planning efforts that we might be able to pull together in sort of a statement, at least, if not a legally binding tool at the outset, just sort of an opening offer, if you will, for those interested, state and federal, to come together and talk about what more cooperative planning might look like. And this is where I turn to some of the work of the Alaska Arctic Policy Commission and then also to those federal Arctic policies and the discussion of integrated Arctic management. So, as Fran said, the time is now to comment on the Alaska Arctic Policy Commission recommendations and drafts. That commission involves stakeholders from a wide range of interests. Its draft report, that's now almost a year old, contains the abbreviation CZM, Coastal Zone Management, but not the words or a discussion of coastal zone management. But I know there's growing interest in it just from talking to some of the commissioners. The thing that is important about it is that that report identifies many issues that could be addressed by coastal management: erosion, sea level rise, oil spill response, facilities siting ports, resource exploration activity within and beyond state waters. Those all implicate the need for some sort of planning. Of those 16 or so federal Arctic policies, turning to those, I just want to focus on one, and that's a report to the President that David Hayes' committee, that Fran mentioned earlier, put together, talking about integrated Arctic management. And it defines that as follows: a science-based, whole-of-government approach to stewardship and planning in the U.S. Arctic that integrates and balances environmental, economic, and cultural needs and objectives. It is adaptive, stakeholder-informed means for looking holistically at impacts and sensitivities across the U.S. Arctic. So I guess a question for the Alaska Arctic Policy Commission is, and I can do this in my comments, but also raise it here, maybe propose that the state take the lead on showing what this still pretty vaguely understood concept of integrated Arctic management means, right? Can point to concrete examples of how it's worked in the past. And I would say many folks would say that the ACMP actually was a really good example of integrated Arctic management. So even though it's not functioning legally, it could be proposed as a model for adaptation and improvement, and getting very concrete suggestions from across the board, those who are for it and those who are against it, to take a look at, how can we take that and move on to something even stronger and even better. And then I'm going to get to the really, what now appears to myself as a kind of harebrained idea, but it's what started this whole inquiry. And this is where a little knowledge is dangerous. So in looking for forums where the states and the feds work well together, the North Pacific Fishery Management Council, which is a federal body, but it came to mind because that is where the state of Alaska does work well and seems basically content with its role in a narrowly focused, Mike will laugh because he's just sat through a week of meetings of the council, but they're focusing on one issue: fisheries. It happens to be the case that for that particular council, Oregon and Washington State are also represented. The Alaska governor basically gets to appoint the head of the fisheries agency here to sit. Other than that, the only role the state has in actually forming this committee is nominating state representatives from basically the commercial fishing industries and some other interests. But so you have a basic structure of a council with appointees by both federal and state authorities. You have working groups that have very focused tasks. You have advisory panels from the relevant industry. You have scientific and statistical committees. Could you take that basic outline and apply it to whether you want to call it the Arctic Coastal Development Commission or some sort of statewide planning commission. It's an interesting idea, but as I began to dig deeper into it, the legal challenges behind it are just quite, I won't say they can't be overcome, but it is a federal body. Again, you would have lost the piece if you have to look to state law to direct what's happening in your particular working groups. There's also the problem under the Coastal Zone Management Act, which is the federal act that authorized the state program, that you have to have a state body implementing any sort of coastal management program. Would it be possible to turn this basically federal structure into a state body? Or to use it as a model for a state body, so then you would have the same structure that the Coastal Management Plan put in place? And then I sort of circled back to, well, yes, you could, but that's what we had. So sort of ended up where the state left off in 2011. So I think I will stop with that. One other thing I have not mentioned that I think is important is ecosystem-based management. I'll stop with that so we can enjoy that picture again. But that ecosystem-based management is also something that the North Pacific Fishery Management Council is beginning to look at concrete ways for bringing into its management of fishery resources, and that might be a useful tool or concept to pull into any revival, if you will, of the coastal management program. So for the experts in the room, thanks for your patience. For the folks new to the Arctic, thanks for your attention, and thanks for everybody's interest. Appreciate it.
Thank you. I think what we've heard is the complication of an area from a government regulatory perspective, and we start with both the cultural and the historical complications. Your map made it more complicated. So we have a chance for some commentators who can share their experience and their perspectives. So Bruce, thank you.
Thank you, Professor Metzloff, and thanks for the opportunity to be here. Those were very interesting presentations, and I really appreciate the opportunity to join and lend a perspective. I have a unique perspective on the issues that we're talking about here today, having been as an assistant attorney general with the state of Alaska. I was representing the state resource agencies that were in charge of the permitting that often gets assailed by industry and by conservation mines on the other side. And now I'm at Cook Inlet Region Incorporated, which is one of the Alaska Native corporations, and we are charged with responsible resource development. So I'm kind of on the project side. And I did a stint in the middle there at the regional solicitor's office representing Department of Interior and what was the MMS, which has, of course, now been split up. And so I've got unique perspectives, I think, on a lot of the topics that Betsy brought up. You know, the regional corporation mantra is balance and stewardship. And you can't develop your way into energy independence, and you can't conserve your way into energy independence. You have to find a workable, balanced model in order to get there. As ANCSA corporations, we're for-profit companies, and we have a fiduciary obligation to our shareholders to maximize revenue and dividends for our shareholders. We also have a responsibility to preserve and protect the very resources and lands that have sustained those very same shareholders for thousands of years. So who better than ANCSA corporations to be able to look at this and try and strike that very balance that I think we're all here trying to find. In reading through the paper that Barry Zellner presented on, and Mr. LeVine was co-author of, I'll take a quick poke at it. I found it interesting that on the in the paper, I got to page 24 of 27 or so pages of the paper before there was a reference to the requirement of the federal government to consult with the Alaska Native corporations when defining federal policies that could affect tribal entities. And as it's stated in the paper, there's perhaps a protocol that could facilitate consultation. And I guess I'd point out that it's a little bit stronger than an aspirational effort to facilitate consultation and cooperation. It's federally mandated that the Department of Interior and others consult with the Alaska Native corporations and the tribes before there's any federal action that's taken that could affect those tribes. And I just wanted to amplify that point because I think it's a pretty important one and one that we take very seriously and bring to the attention of Interior if ever they abrogate their responsibilities in that area. So, I do think that with respect to stewardship, no really entities are better stewards of the environment that we're talking about here in the Arctic than the indigenous local populations. And I'll take another quick poke at the academics in the room. I think it's great, that you have scientists coming up to the slope to spend time studying things with piezometers and seismology equipment and wind meters, et cetera. But it's really the folks that have lived there for 1,000 years that have the actual knowledge about how that environment works in a systemic way. And so, when scientists come to the slope for 6 months to do that, I think that's great. And to lend to a dissertation or to get a couple of initials after their name. But at the end of that day, when they've been up there for a couple of months, they become the experts on those topics. And I guess I would suggest to you that rather than lending credibility to folks that have spent a couple of months in an area to study things from an academic perspective, that perhaps greater weight be lent to comments by those who've actually lived there and understand that geology and climactic interaction based upon thousands of years of occupancy and use. To Betsy's excellent points that she brought up with respect to the ACMP, first of all, I endorse the basic thesis as to the value of the ACMP. And in fact, if we're searching for something that brings to the fore the type of coordination and interaction, I really don't see a better model than the ACMP. It was unfortunate that it died in 2011. What ended up happening, and I should point out that I was the attorney from the state that was charged for several years for representing the ACMP related matters, all of them litigation and permitting, and so I know quite a bit about the program. And I will say the program functioned pretty well. It contained a lot of the headbutting that you would expect in any sorts of process when you have conservation and development interests that are fighting for the same turf. And yet when we get to 2011, when the program was set to expire by its own statutory terms, you had the House of Representatives in the state of Alaska come together, and by a vote of 40-0, they wanted to reauthorize the program in substantially equivalent form as it was. And then when it got over to the Senate side, it became a political football that got kicked around. And unfortunately, in my opinion, it got Christmas treed to death, and to the point where it fell over and expired. And I think that's very unfortunate for several reasons. The first is a point that Betsy made with respect to federal consistency. That is a tremendously powerful tool for the state of Alaska and the federal government to have that collaborative relationship that Betsy referred to. Through federal consistency, let me back up for a second. The state of Alaska's spill response and prevention regulations are far stronger, far more stringent than the federal equivalents. And through ACMP, through federal consistency, those federal projects and projects occurring on federal lands would have to comply with those state DEC standards in the OCS, but only if you have an Alaska Coastal Management Program. Otherwise, that federal consistency goes away. There is, and I apologize, I was kind of scratching notes that I'm now trying to interpret. Predictability and expedience. The ACMP was extraordinarily, I think, beneficial in those regards. When you're in the boardroom, as I am now, and I have been in other positions, trying to determine what projects to do, where to allocate your capital, you look at the permitting timeline as one of the most important factors in your consideration after you do a cost-benefit analysis and some other economic metrics. The ACMP as it was provided the type of predictability that industry could rely upon so that they could have a Gantt chart and say, when we get to here, we'll be through this permitting process with whatever mitigations are required by law. That was extraordinarily useful and valuable, and I'm sorry that it's gone. And last thing I guess I'd point out on the ACMP is money. We are a cash economy, and through the it's called the CAPS program, the Coastal Impact Assistance Program, the states with an approved program got money from the federal government. I believe the last year of its existence, the state of Alaska got $5.6 million from the federal government to administer the program on the local level. The coastal districts had that money distributed to them through the borough and the unorganized boroughs to be able to have coastal district and enforceable policies and have offices to be able to staff those and enforce them. And to have lost that and lost that infrastructure is, to me, again, a sad thing. The third and final point I wanted to address, and I apologize I was not able to hear the morning presentations, and I wish I had, but if it was discussed, I apologize, and that's OCS revenue sharing. I think this is a really important piece to the puzzle. As folks probably know, for onshore federal leasing, 50% of the revenues generated by the federal government goes to the host state. Within the 3-mile jurisdictional state limit, the 8G zone, as we call it for the coastal or for the CS LA, you have a 27% kickback to the host or home state for federal revenues. You get beyond 3 miles, and as it is today, there is 4 states that have revenue shared by the federal government with them, and those are the Gulf states, Louisiana and Mississippi, Texas, and Alabama. Thank you. So those 4 Gulf states get a kickback of 37.5% for federal revenue sharing. I strongly believe that that needs to be expanded to all coastal states. Senator Murkowski introduced a bill last year. It was entitled the FAIR Act. I can't remember the exact acronym, but it was I think it was Finding or Fixing Acceptable Inequities in Revenue Act, something along those lines. So it was fairly descriptive in her mind that there was an inequity here, that you have the state with 6,000 miles of coastline, more than all the other states combined, that is not entitled to a share of the revenue that is produced from activities on its OCS, particularly when you consider that it's the state that provides the roads, the airport, the marine terminals, the spill response capability and equipment. The coastal states need to be recouping some of those expenses through federal revenue sharing, in my opinion. And one final point on that, and I'll close with this, which is a political point. Whether Governor Parnell wins the gubernatorial election coming up, or his challenger, Mr. Walker, wins, I don't see the ACMP being likely to come back under the current political conditions. Even if we turned our existing legislature over, I just don't see that there's the political will to do it. However, if there was federal revenue sharing and you had a provision in the federal law that stated that the coastal states will receive its allotment of federal revenue, shared revenue from offshore activity if they have an approved coastal management program, you would see the Alaska legislature and whoever's in that governor's office sprinting to get an approved coastal management program in place. And I believe it would look a lot like what we had. And I think that would be a good thing, and it's something that we ought to be thinking about in terms of lobbying our federal delegation. So, thank you.
Sure, I'm going to be really brief, and I'm going to stay here because you guys will see me up at the podium in the next session. But very briefly, the presentations made me think of a couple of points. First was the question I asked Fran this morning. Obviously, I come down the same place as she does, that a coastal zone management program is both necessary and desirable, and we ought to have one. Also, and this is kind of goes to Barry Zellen's first presentation, we're fond in Alaska of saying that there's no one-size-fits-all solution to anything and that we're unique, right? And this is one of the things Fran was talking about this morning, trying to bring the Arctic to the rest of the U.S. But it's also important to recognize that within 6,000 miles of coastline, we're not all the same there. That Arctic map stretches all the way down to the Aleutian Islands. You've got some of the biggest fisheries in the world in the Bering Sea, some of the most explored ocean around, goes all the way up to really remote places in the Chukchi and Beaufort Seas. It's a vast coastline. It's different. The state is different culturally, scientifically, and then even as you try to break it down into ecoregions, even within these seas, there's differences. We have this tendency to treat the ocean as if it's all the same, and it's not. And there are methodologies in development as part of this integrated Arctic management program to try to figure out what's in the ocean, what times of year, how does it interact, what's the baseline of information we can find as we try to predict the impacts of different kinds of activities. To answer, at least as well as I can, some of the questions that Betsy posed, and I will resist the temptation to get into the council process, other than to say that not all of them work as well as the one here. There are 8 of those regional councils, and 6.5 of them are dysfunctional, and we happen to work in one that works pretty well as far as it goes. There are a couple of other decision-making structures. Bruce talked about the tribal consultation and corporate consultation. Were those kinds of consultations truly meaningful? That is the potential way to bring local input to decision-making process. I don't believe that for the most part they are. Another possible model is a regional citizens advisory council. We have one in Prince William Sound. It's just another thing to think about as we're thinking about decision-making structures. And I would want to close with 2 points. One is that if you're really going to get to durable solutions, decision-making, it needs to be inclusive. And one of the ways to think about it is within concentric circles. Start local, build out to regional, to statewide, to national. And if you can include people in that decision-making process from the beginning, include what they know, include their perspectives, you can build, at least one would hope, you can build toward longer-term visions and planning and solutions. And the second point is that at the heart of that concentric circle approach is science, is good science about ocean. I know about oceans, about ocean ecosystems, let's say, and that includes local and traditional knowledge. And one of the things we can do here in this state is try to raise the profile of the idea that science is good, right? We want science. We want to understand what's in the ocean. And if state and federal government and corporate and tribal entities could all work together, it's an economic engine. It costs a lot of money to do science. There's federal funding for this stuff. We could create and improve economic opportunities in the state by improving the scientific basis for our decisions. And that's a place that we could all work together. And it's the potential for the beginnings of some of this concentric circle approach to solving problems. If we can all agree about what questions need to be answered, who's going to answer them, how we're going to pay for them, these are things that are apolitical for the most part and just go toward better decision making. And I suggest that as a place to start at least thinking about answers to these questions.
Thank you.